Let me. Okay, now I can speak. Forget everything else I said before that. When the Southern Delaware Alliance was founded in 2015, its major focus was the criminal justice reform. The vision of the Alliance is the elimination of racism and its corrosive consequences. As some of you may recall, we were greatly influenced by the writings of Bryan Stevenson, who wrote Just Mercy and whose life work was committed to working on behalf of the wrongfully convicted, especially those on death row. We were also influenced and inspired by Michelle Alexander, who wrote The New Jim Crow, Mass Incarceration in the Age of Colorblindness. Mrs. Alexander's hypothesis is that the American penal system has emerged as a system of social control unparalleled in world history. She proceeds in her book to dissect and analyze all aspects of the criminal justice system, from arrest, pre-trial, incarceration, sentencing, plea bargaining, non-diverse juries, lack of adequate legal representation, to support her belief that the imprisonment of Black people, especially males at any age, has the same purpose as the Jim Crow era, but worse results. For Black people, they are locked up and then locked out of the mainstream society. We have not ended our racial caste system. We have redefined it, but this time around through a seemingly legal but unjust process. It is my understanding that we do not know how many innocent people are incarcerated, and perhaps our speaker will give us some estimation. A few studies indicate between 2.3 and 5.9%, which would mean between 40,000 and 90,000 in our American and our U.S. Penal system that are innocent. While I have alluded to the racial implications in our systems because of the mission of the Alliance, I am well aware that the incarceration of innocent individuals include men and women of all races, white, Black, and brown, and other, but that the majority are people of color. Tonight, we will learn from Mrs. Claudia Trupp, Executive Director of Delaware's Innocence Project, a vital program focused on reversing the conviction and imprisonment of those individuals who were wrongfully convicted of crimes that they did not commit. There are remarkable stories of individuals exonerated after 40 years of incarceration for crimes that they did not commit, or the release of men and women from death row who face each day, perhaps for years, waiting for the date of their execution. I assume that there were those individuals who did not have the support of an Innocence Project or pro bono legal representation or community support that were executed, though innocent. And let me say in conclusion, if we believe in the value of life, the power of justice, the elimination of racism, and the right of every American citizen to be entitled to the protections embedded in the Constitution and its amendments, then the work of the Innocence Project, the Alliance, and all such organizations that share these beliefs is absolutely essential for a better world. Hopefully, the Innocence Project will help to fix our broken criminal justice system. I'm going to turn the program over to Court Jones, who is a member of the SDARJ Steering Committee and the chair of our Outreach Committee, who will introduce our speaker. Thank you.
Good evening, everyone. Thank you all for joining. With us tonight, as you have heard, is Ms. Claudia Trupp. She is the new Executive Director of the Innocence Project Delaware. She joins the organization with years of experience representing wrongfully convicted people in a post-conviction proceedings. as the founder and director of the Center for Appellate Litigators Justice First Project. She supervised teams of attorneys, volunteers, and investigators in complex investigations. The project enjoyed tremendous success under her leadership and was recognized as a model of excellence by the New York State Bar Association. Last year in the case Hemphill v. New York, her client prevailed before the United States Supreme Court. The court ruled the accused does not waive his right to confront the witnesses against him merely by asserting his innocence and blaming another for the crime. In addition to her expertise in wrongful conviction work, Ms. Trupp founded and directed the Center's parole advocacy, conditions of confinement, and reentry projects. She has also taught and lectured on various topics relating to criminal law. She is the mother of 3 daughters. She has published a memoir called Hard Time and Nursery Rhymes about her experiences raising them while working as a public defender. Please call Browse About, have them order it, or it's available with Amazon. She looks forward to bringing her expertise to the Innocence Project Delaware's mission of helping to free those wrongfully convicted in Delaware. So please welcome tonight, Ms. Claudia Trupp.
Oh, okay, so I should be here. Is that good? Well, thank you so much for those introductions, Court and Charlotte. As they mentioned, I'm relatively new to Delaware. I spoke to Charlotte this summer, and when I heard of the mission of the Southern Delaware Alliance for Racial Justice, I knew it was a place that I wanted to come and speak to you, because the mission of Innocence Project Delaware in helping people who have been wrongfully convicted of crimes they didn't commit is one that overlaps with racial justice. They speak of wrongful conviction as the new civil rights movement, and we're going to be talking tonight about the factors of wrongful conviction, but also how race permeates every aspect of our criminal legal system and results in a disproportionate number of people of color being subjected to the tragedy of wrongful conviction. I'd like to talk a little bit about my experiences, some anecdotes about my own experience and what brought me to this work, which I've been in for a very long time now. It started really, strangely enough, when I was a teenager. I was raised in the suburbs of New York, very privileged background, father a doctor, mother a teacher. On my brother's prom night, when I was 14 years old, I was watching a movie with my father when 2 armed men came into our house. At that time, we didn't even lock our doors. It was, the type of neighborhood you never locked your doors. 2 armed men came into our house and tied us up and proceeded to rob and steal a number of our possessions, separated me from my parents and kept me in a separate room, and eventually, thankfully, let us go. And the police were summoned to the house and interviewed us. And it became apparent to me from that experience that just how unreliable ID accounts can be, eyewitness accounts can be. Because while all 3 of us had the same experience, we all described it in completely different ways. We all described the people differently. We described the series of events differently. And there's nothing like that firsthand experience of the fallibility of individual observation to really bring home to you how vulnerable our system is to making mistakes. Flash forward to my time in college. I was up at the University of Rochester, and I was interning at the prosecutor's office, and I was in a narcotics bureau. And from that experience, it became very apparent to me that every single person who was being prosecuted, every single trial on which I was assisting, involved Black and brown people being called to account for drug crimes that I saw my more well-off student colleagues committing a similar type crimes in terms of either using or purchasing or selling drugs, and not ever being prosecuted, while people that I was working to prosecute with the prosecutors were being held to account without any mercy. And I found myself in those cases, even though I was working for the prosecutor, always working for the defense, always rooting for the defense. So flash forward to when I came out of law school, I went to work as a public defender doing post-conviction work. And I exonerated in that capacity my first client when my middle daughter had just been born. So that was in 1999. And I use that statistic because the National Innocence Project began its work in 1992. I started doing wrongful conviction work in New York in 1999. And the Delaware Innocence Project Delaware, was started in 2018. And we didn't begin accepting cases or reviewing applications until 2020. So that gives you a sense of how far behind we are in terms of reviewing cases in Delaware and just how much work we have to do here. How our process works is that we receive applications from people in prison all over the state. We are housed in Delaware Law School up in Wilmington at Widener, but we receive applications from people from every aspect, every part of Delaware, and every single application we get is carefully reviewed. And we have specific criteria that make people eligible to receive our assistance. And so in order to be eligible to get help from us, people have to say that they're actually innocent. So I was a public defender for 30 years. And in that role, we never really asked very often whether our clients were actually innocent. When you're a public defender and you're doing post-conviction work, the focus is really on the process and on the fairness of the process, whether the sentence was too excessive or procedural protections weren't adequately in place, or whether the defense attorney wasn't, effective. But when we're doing the work of Innocence Project Delaware, we're really focusing on factual innocence, on whether somebody actually did not commit the crime for which they've been convicted. And that's a different question. We also look at whether somebody's still in prison. We're a very small office, and so we have to make sure our resources are focused on people who most need them. And so we look to see if people are serving lengthy prison sentences. And we also look about if they have had an opportunity to have their appellate remedies exhausted, meaning they've been through the appellate system. And then we look at whether there's new evidence that can be developed. And only after all of those questions are affirmatively answered is somebody accepted into our project for investigation. So with those strict criteria in mind, I'd like to just talk a little bit about, and maybe we can start the PowerPoint, about why, how innocent people get convicted and why it's so hard to undo it once they do. So if you can just advance. Can we? All right. Well, all right. So what is an exoneration? Everybody recognize that from Monopoly. So in general, an exoneration occurs when a person who has been convicted of a crime is officially cleared based on new evidence of innocence. So that's what we're looking to do in our project. Exonerations nationwide. There have been 575 individuals who have been exonerated through DNA. 5 of those have been exonerated posthumously. And I just want to say that every day there are more exonerations. And so whenever I make a slide, this was as of, I think around a month ago that I updated this. But so keep in mind that there's probably been more since this slide was created. Next. There's been approximately 3,319 exonerations, DNA and non-DNA, since 1989. And that represents more than 29,500 years of lost life. And when people are falsely convicted of crimes they didn't commit, they're taken away from their families, from their communities, and they lose everything that they have had. So continue. It's estimated that approximately 9,969 people in the United States may be wrongfully convicted of serious crimes each year. But the truth is that that's an estimate. We don't know exactly how many people are wrongfully convicted every year, but we do know, and this has been a source of controversy for hundreds of years. There was a time where people really believed that people weren't wrongfully convicted, that, our system was so infallible and there were so many protections that wrongful conviction was unlikely to happen. And the lesson of the DNA exonerations and of the work of all of the innocence organizations across the United States is that we know now that innocent people get convicted, and we know just how fallible our criminal legal system is. Next slide. So this is exonerations by contributing factors, and you can see all of the different factors that have been found to have led to wrongful conviction. So we see about, witness misidentification, perjury and false accusation, false confessions, and false forensic evidence and official misconduct. And you can see how often those occur in that bar graph. But we see common factors that contribute to wrongful conviction in almost every case that results in an exoneration. So factors in wrongful conviction. 66% of wrongful sexual assault convictions involve erroneous IDs. Now, I find that statistic really surprising, because if you think about sexual assaults, when we think of them, these are not, things that happen at a far distance. They're up close and personal encounters, and yet in 66% of wrongful convictions, they involve misidentification. 42% of exonerations involve official misconduct. That means situations in which police, prosecutors, and judges are acting in a way that contributes to the wrongful conviction. And 72% of wrongful homicide convictions involve official misconduct. And the reason for that is because there's so much pressure when a homicide occurs for the police to solve the case, that oftentimes it results in misconduct on the part of the police. And one type of misconduct we see is the eliciting of false confessions. So we have cases at Innocence Project Delaware where we look through, 11, 12 hours of interrogation tapes, and you can see the pressure that's being exerted on the person who might be coming down off of drugs, who might be suffering from low IQ or various substance abuse problems, and you can see the pressure that's being exerted on that person by the police in an attempt to get the person to confess because they want to solve the crime. And 24% of all exonerations involve faulty or falsified forensic evidence. And I think people find that surprising, because you think, oh, it's scientific, right? It's reliable. There's the matching of the guns and the bullets, and there's the comparison of fingerprints. And we want to believe that forensic science is reliable and that it can help us solve crimes. And, we all have watched CSI and all of these. We expect that science is going to prove everything. But in fact, there's a lot of problems with forensic science, and 24% of all exonerations involve falsified forensic evidence. So have innocent people been executed? Yes, we know that they've been executed. We'll have a few examples here that we can talk about. So in 1939, Joe Reedy was executed for a crime he could not have done. And in 2010, Colorado Governor Bill Ritter issued a full pardon declaring him innocent. In 1989, Texas executed Carlos de Luna for a crime likely committed by another. And on February 17th, 2004, Texas executed Cameron Todd Willingham for a fire homicide, where it was later determined it most likely was an accidental fire. So, next. So now we're going to go through some of the factors, look at them a little more closely. Some eyewitness misidentification is a leading cause of wrongful conviction. I think a lot of people know that or aware of that. So how does memory work? I think there has been a perception, at least when I was coming up as a public defender, that memory works like a video recorder, that you can look at something and then, to recall it, you just have to play back the tape. But what we've learned through studying how memory works is that it's really much more like this. It's much more that your mind perceives things and you construct a narrative of it and you try to piece together what makes sense. And so unlike an accurate recording, the mind and the ability to identify what has happened, we talk about it as if it's a crime scene. And things that happen during the course of the investigation can taint that crime scene and make it impossible for memory to be accurate. And once memory and eyewitness identification is tainted, it's impossible to undo. Next. So the first part of any eyewitness encounter is what you perceive. And remember, when I was talking about that incident with my family, we all had different perceptions of the same event. And so what does everybody see here? Anybody? It's a duck. Okay. Anybody see something different? It's a rabbit. Okay. So you see, people can see the same. Oh yeah, there it is. So people can see, some of these are really funny because I really can't see the different things, but hopefully you guys will be able to. So if you were being asked to identify this culprit, some of you would say it was a rabbit and some of you would say it was a duck. But that is just an example of how we all perceive things differently. And perception is the first part of eyewitness identification. So next. What do we see here? Okay, I hear a face. Okay, anybody see anything different there? All right, so I see like a little Red Riding Hood figure like in front of some buildings. Does everybody see that? Okay. Yep, so next. All right, this one I cannot see the difference. I see a blue and black dress. Does anybody see anything different? I see a blue and black dress. What do you see? You see brown. Anybody see anything else? Some people see this as totally a different color, this particular thing. I always see it as blue and black. But anyway, so people do see the colors differently. You see brown, Charlotte? You see what? You see brown and white. That's fascinating. Does anybody see brown and white? Okay, anyway, so you're just seeing how we all see these things very differently. Okay, next. What do people see here? Okay, does anybody see white paint on the legs? Yeah, okay. So we're all getting the sense of that we can perceive things differently, and think about if as witnesses you were being asked to describe this later on, you would have that same experience that I spoke about at the beginning about how we're all perceiving things and describing them differently. So next. So the role of an eyewitness, you have to perceive, you have to store the information, you have to retrieve that information, and you have to communicate it. And at every step of that process, we can see problems that make that testimony less reliable. So next. So where can eyewitness identification go wrong? I mean, I think a better question is where can't it go wrong? It's that memory for faces is basically unreliable. The traditional lineup methods that the police use cause people to make relative judgments. And if they're suggestive in any way, it again taints and contaminates that memory and ability to identify. And once it's affected, it cannot be reinstated, and even honest mistakes cause permanent damage to memory. So has anybody heard of the case of Ronald Cotton? Yeah, I see some people. So the person who was raped in that case identified Ronald Cotton as her assailant, and then DNA testing proved that Ronald Cotton could not have been the person who raped the complainant. And the complainant and Ronald Cotton became friendly, but she said that for the longest time, even though she knew scientifically that it could not have been him who raped her, when she recounted the event, she always continued to see his face. She could not erase that once that impression had been created. So we know that there's so many ways that eyewitness identification goes awry. There can be, and we're going to go through some of these, but one I want to tag for you is the absolute difficulty that people have with cross-racial identification. This is something that we have only come to realize and understand more fully more recently. So now in a lot of jurisdictions, there has to be a jury instruction that advises the jury of the difficulty of that people have accurately identifying people across races. And so what that means, and it really goes back to if you were raised in a community that was not diverse, your ability to identify people is formed at a very young age. And so if you weren't surrounded by a diverse community at a very young age, you will not be able to make those identifications in an accurate way. And because the United States is such a segregated society, we see that cross-racial identification is really problematic. We also are learning to a lesser extent that cross-age identification is also very difficult. And I sort of got a clue of this with my own kids, because whenever I would ask them, how old is your teacher? I would get, she's old. And I'd be like, what do you mean? And she's like, she's your age. So anyway, next one. So one of the things that really impacts the ability to accurately identify somebody is the amount of time, the duration of the crime. But what do we know about crimes? Very few people commit crimes in a leisurely way, right? Oftentimes, crimes are committed in a very quick way. And so there's not a lot of time, and it's not in a way that people are expecting it. So the one of the cases that I worked on in the Supreme Court involved an incident on Easter morning where a shooting took place it was Easter morning. Everybody was just gathering around and talking and walking. And then a shooting took place, and everybody described that shooting differently. It was just an instantaneous thing, but everybody described what happened differently. And so because it was such a quickly evolving event, we see that people cannot accurately recount what happened. Next. Weapon focus. So we find that when there is a weapon involved in a crime, that really takes away from what people can accurately recount. So I told you that when my family was brought together to talk to the police about that incident, we all described the perpetrators differently. But one thing we were all consistent on was the appearance of the guns. We all could describe those very accurately, because when you have a gun in your face, that's really all you can focus on, because the gun is what separates your living self from, dying self. And so that is really all that you can focus on. Whoops. Technical difficulties. So another factor that we find really impacts the ability to do an accurate identification is stress. And this is sort of counterintuitive, because when I was working as a public defender, oftentimes what we would hear the prosecutor say is, think about how terrorized this poor person was. Will she ever be able to forget the face of the person who terrorized her? And the answer to that is yes, because when you're under tremendous stress, when you are incredibly fearful, memory is created. It doesn't get laid down in the same way. And so your ability to recall is compromised. And so when you're in a stressful situation, as these people are in the next slide, you are not going to be able to recount what happened as well as if you are looking at things in a relaxed and calm manner. So, and we already spoke about cross-racial identification, how we know that it is very problematic and difficult for people to get right. And it's not really a question of intentional bias. We can go through this one. It's a question of just an inability to do that accurately. So how do eyewitnesses' identifications go awry? There are a lot of factors that can contribute to the unreliability. So when the police interview people, you can see that mistakes can be injected into it. We also see identification procedures, which can be suggestive, and that the types of identification procedures that police use encourage people to make mistakes. So we're going to go to the next slide and we'll see. So one thing that people don't understand about forgetting and the ability to perceive. A lot of people think of your ability to perceive and accurately recall diminishing gradually over time. Science teaches us that, so this is the common belief that, it's a gradual diminution, day 2 is fine. But really what science teaches us is that it's much more precipitous, and that immediately after an incident, the ability to recall accurately diminishes rapidly and irretrievably. Next slide. So that's really actually the forgetting curve. It's really very precipitous and very quick. So next one. So when people are victimized, they are often exposed to mugshots, and mugshots have a way of making everybody, even the best of us, if we're in a mugshot, the best looking people look very bedraggled and potentially guilty in mugshots. And the more you're exposed to them, what often happens in terms of identification procedures is somebody is shown a series of mugshots, picks out somebody, and then a lineup is done. And so you have repetitive viewings of a suspect. So let's go to the next thing. So here's a question for you. Who was the highest scorer in the NBA in the 1980s? Larry Bird. Who's going to vote for Larry Bird? Charlotte has Larry Bird. Magic Johnson. We got a Magic Johnson. Michael Jordan. Okay. 2 for Mike and Kareem Abdul-Jabbar. Oh, everybody's a Kareem Abdul-Jabbar. Who's right? Let's see. None of the above. So who was the highest in 1980s? It's Alex English. Yes. Yeah. So yeah, there you go. Some basketball fans here. That one, people knew that. Okay, but here you go. The reason why I use this example is that what did we find? We found that people were making comparative judgments and coming to a conclusion based on the amount of offerings that were there. And similarly, that is the same with identification procedures. So let's go to the next slide. So we talk about relative judgments, and when you see you can just go through these. You're gonna see that. All right, so in this situation, all the witnesses were warned that the actual perpetrator might not be in the lineup. Can you click? And so when that happened, 54% said that it was the person in the 3rd slot, and 21% said they had no choice. So let's go through. So 54% for number 3 and 21% no choice. Go through. Now we're going to remove the 54% one. And so you would think logically the no choice would go up to 21 plus 54, which would be 75. Okay, good enough. So go ahead, you can click through. So plus 54. So 75, right? Everybody got the math right. Okay, so we're going to remove that. And so that's what you would expect. But look what happens. Only 11% then say they have no choice. So 32% have no choice. And then what happens to the remainder? They go to the next person who looks the most likely, and he becomes 38%, and the rest are spread around. So the others go up. And that's because people are looking to come up with the answer, just like we were all looking to come up with the highest score when we were off given those options. So yeah. Yeah, they do. Every jurisdiction is different, but yes, they do still use those as well. Okay, so we're going to go. I mean, there's also a difference between the ability to recognize somebody and the ability to describe them. So, okay, so you would all know who this is, but if you had to describe him, you would all describe him very differently if we went through and did that. So, okay, lineup composition. So oftentimes we have lineups that are highly suggestive. And once you have one of those highly suggestive lineups, it's very difficult, as we've said, to undo that. Okay. Composite sketches are another tool in the police arsenal that can cause people to misidentify people because, again, the ability to describe the person might not be as accurate as the ability to recognize the person. But once the composite sketch is done, then you're looking for somebody who looks like the composite sketch, even if the composite sketch has not been accurately done to be consistent with the actual person who did the crime. So this is an interesting slide we'll see next. So here is a composite sketch with a newscaster talking about this rapist, and he looks exactly like the composite sketch. So shows you how unreliable they can be. Okay, so incentivized testimony is another aspect of our criminal legal system that is very disturbing and very problematic, and we see a lot of it here in Delaware. So we talk about snitch testimony is the number one cause of wrongful convictions in capital cases. Okay, next slide. So we know that jailhouse informants. Does everybody know what a jailhouse informant is? It's somebody who comes forward. We see a lot of this in Delaware where people come forward. They say, "Oh, I was on the cell block with this person who's on trial, and he told me that he committed this crime and provided details about the crime." And whenever we see jailhouse informant testimony in a case, we become concerned because generally speaking, juries don't like jailhouse informants and prosecutors don't like to use them because of the problems inherent in their use. So if we see a jailhouse informant in a case, we know that the prosecution felt that they really needed to add that to the case. And so it makes us think that the prosecution's case probably in their own assessment wasn't that strong. And so in 15% of cases of wrongful conviction overturned by DNA testing, it has involved an informant or jailhouse snitch that testified against the defendant. So when we talk about jailhouse snitches are not the only type of incentivized testimony. So another common type of incentivized testimony is accomplice testimony. And that's where we see that right now down in Georgia in the RICO case where, there's a number of defendants and people are coming in and they are testifying in order to get a better deal and to save themselves. And there's an incentive for people to come in early into cooperation because the best deals are given to those who come in early. And so we see a lot of cases where accomplices, maybe even the person who pulled the trigger, is testifying against the person who was less involved in exchange for a beneficial plea bargain. We just talked about jailhouse snitches, but there's also other types of incentivized testimony. I've had cases in my career where people were given cash straight out or offered, a new apartment to be relocated because they said, oh, now that I'm cooperating with the prosecution, I'm afraid for my life. And so they get a new apartment, they get relocation expenses. So we always have to be, or another big thing that we see is immigration assistance, right? Sometimes by cooperating with the prosecution, people can get special visas. So victims of who allege sexual assault can get and cooperate against people can get different types of visas that allow them to stay in the country. And so there's many, many reasons and many different sources of incentive that the prosecution can offer that the defense doesn't have at its disposal, right? As defense attorneys, they can't offer to help somebody stay in the country. They can't offer to relocate somebody. That would be bribing the witness. But the prosecution has a great arsenal in its power to use to help create incentives for witnesses to help them with their cases. Next slide. So false confessions, 22% of all homicide exonerations involve false confession. And again, as I mentioned previously, it's because in cases of homicide, there's so much pressure on the police to solve the crime. And so we see people being put in rooms, isolated from their families, and very coercive methods of interrogation used against them. Next slide. So here are some factors. And, a lot of people think, why would anybody confess if they're not guilty? I personally never think that. I think that, like, you put me in a room and don't give me food, I'd be saying anything you wanted me to in like an hour. I'd be like, I'm hungry. Just give me a Big Mac. but a lot of people feel like there's no way that I would ever confess to a crime that I didn't commit. There's no way that I would ever plead guilty to a crime that I didn't commit. People who say that are just not well versed in the extraordinary pressure that can be exerted on people. And even things that don't seem like they should be create so much pressure, like just isolating people or invading their space or just not listening to what they're saying, or yelling at people. All of these things have been proven to induce people to falsely confess. And there are certain people who are just more vulnerable to false confession. And those are people, as I mentioned before, who might have been intoxicated or have some form of diminished capacity. And it's really unbelievable how convincing, as a public defender, I've watched confession tapes where I subsequently found out that the person was innocent. Like it was a full out exoneration. We found the person who actually did it. The prosecution admitted it was the person, my client was innocent. And when I go back and look at those false confessions, I'm like, they're so convincing. It's just really strange to, once you know somebody's innocent, to watch a false confession and how believable it is. And I'll tell you something, the United States Supreme Court has said a confession is like no other piece of evidence. And it really is. Like when you see a person on tape confessing to a crime, there is a real human nature to credit it. And so it is so counterintuitive that false confession is as prevalent as it is. Okay, sure. Right, right. Well, there's also, we see police officers doing things like minimizing what happened. Oh, it was a mistake. You didn't realize that you had smashed into somebody and you just felt like maybe something go under your wheels, but remember when that happened? And people are like, yes, that must have happened. And especially with people who are young, intoxicated, have factors of lesser capacity, you're going to see that over and over again. So it actually does happen. So yes, so we just thank you for sharing that. It's very timely. The next slide says adolescence and immaturity, and there's just a recognition that teenagers and young adults are much more prone to false confession. Next slide. We also see that the Supreme Court has recognized that people with diminished capacity who might have a lower level of intelligence are also very vulnerable to false confession. And the other thing is that, uh-oh. We're okay? We have special dispensation. Okay. So good. And another thing that we're just starting to learn more about, and which has been a burgeoning area of science, is that there are certain people, even who are not young, who are not of lower intelligence, who are not, addicted to drugs, who, because of their personalities, are just more subject to suggestibility and just more subject to false confession. So there can be none of these factors, but you can just be somebody who's more compliant and more likely and more vulnerable to falsely confess. And innocence is also a risk factor for wrongful confession. And why is that? Because what we hear from people over and over again is, I just wanted to get out of there. And I knew I was innocent. So I just told them what they wanted to hear. And I knew I could clear it up later. Wrong. So, but it is a risk factor when you know that you're innocent and you just think that you're going to be able to get out of there and prove that you're innocent. So it won't matter. You just want to go home. So interrogation time is a real risk factor we see for wrongful conviction. If in the average case, an interrogation will take 30 minutes to 2 hours. That's the average amount of time that we see. But when we're talking about wrongful conviction, we see 6 to 12 hours, 12 to 24 hours. And what we really see is people just being ground down, isolated, we see people being subjected to multiple rounds of detectives coming in. Oftentimes when I watch interrogation tapes, it's clear to me that the person is uncomfortable. The room might be too cold, or they're lying on a hard bench. All of these things that are just designed to grind people down and make it so that you just want to get out of there. Sleep deprivation is a really strong one, as anybody who's ever, stayed up all night with a crying infant can tell you. Like the next morning, you don't know what you're doing. Okay, so next slide. So another thing that we see is the police using trickery and the presentation of false evidence to create a sense of inevitability that we know you're guilty. You just have to you're going to make it easier on yourself if you can just admit to what happened. And so I was recently watching an interrogation tape where they were just saying to the person, well, you were really drunk and it was just an accident. And, you didn't mean to start the fire, but you went and you spilled the alcohol and by the end of the 12-hour interrogation, the person's like, oh, that must have been what happened, and there you have it. There's the confession. So the police try to create a sense of inevitability to drive the suspect to a state of despair. They isolate and they interrogate and are confrontational, and inevitably, you can go ahead. If they feel like that it's inevitable, their nature forces them towards acquiescence, compliance, and approval of the narrative that's being presented by the police. Next. And the police are taught to, even when that case that I was talking about, the 12-hour confession tape, the applicant in that case denied setting the fire 242 times. He kept on saying, no, I couldn't have, there's no way I did it. There's no way. And it was just, they would not accept it. And so 12 hours after first coming into the precinct, eventually he's like, okay, that must have been what happened, because you just can't sustain it any longer. Next. And misinformation renders people vulnerable to manipulation. So what does that look like? The police can lie to people during interrogations. They can tell you, your best friend says you were there, or we found your fingerprints on the gun, or we gave you a polygraph and you failed. They can tell you all sorts of things that make you doubt what you know. And after a while, that can really wear away at your ability to keep resisting the narrative that the police are putting forward. Next. Right. So it's, it really can take a toll on people's perceptions. So minimization, we talked about a little bit before when we were talking about the situation where somebody with a hit and run, the police develop themes that allow the person to accept the story that the police are conveying in a way that is less inculpatory, but still a confession for legal purposes. So the accident, it was an accidental starting of the fire, or you didn't mean to hit the person, but people will adopt that narrative as a way of trying to get out from under the pressure that the police are exerting. And psychology shows that people tend to infer leniency from the minimizing remarks. So in other words, if the police are saying it was an accident, or, you didn't mean to, it was a misunderstanding, like she's saying that you raped her, but really it was just a misunderstanding. And what we see a lot is the police being like, we're all men here. We know how women are, and trying to get people to adopt the narrative that the police are offering up. And this particular tactic is very dangerous for innocent people, because they will comply with the narrative that the police are putting forward, the interrogators are putting forward. Okay, so now let's talk about bad science and bad scientists. So bad science or bad scientists has been a factor in 30% of the first 60 DNA exonerations. So there's so many problems with forensic science. And I mentioned before that we want to believe that forensic science, we're living in a CSI world where like somebody can touch something and then we get their DNA and it's all Good, but there's so many problems with forensic science. And for a long time, there was absolutely no standards relating to forensic science. And what we've seen is that in a lot of jurisdictions, there's limited controls to make sure that the people who are conducting tests are doing them accurately. So I was just teaching my students about a lab scandal in West Virginia, where a person in one of the lab technicians in West Virginia was basically just literally making stuff up. In every case, he was saying he could find a match. He matched fingerprints, DNA, everything, just making stuff up. And what they found was that, yes, there was a bad actor who was doing it, but there was also a lack of controls and oversight of the laboratory. And so for a long time, we had labs that were doing forensic work that were not being adequately controlled through testing and oversight and protocols. So, and also what we've seen is that over the past 15 years, a lot of the forensic science that was accepted, things like bite mark evidence, microscopic hair comparison, even fingerprints, which everybody put so much stock in, are much more subject to interpretation errors and fallibility than what we had originally been thought. And so we're seeing a lot of these types of evidence come under scrutiny and be questioned. So we can go on to the next slide. So here are all of the different types of forensics challenges. Oh, did you have a question? Oh, okay. We'll do some questions and answers after. So here are all the different types of forensics that have come under question. So hair analysis is something that's recently the Supreme Court of Delaware just reviewed a case where it was recognized that the FBI, who was doing the hair comparison analysis, was really overstating the accuracy of what could be told by comparing hair. So we have an application right now where the FBI analyst testified that he could look at the hair that was found on the sweatpants and look at the complainant's hair and compare them under the microscope, and it was as accurate in determining identification as DNA evidence. That is just, and the FBI recognized that that type of statement completely is not scientific and was misleading. And so the Supreme Court of Delaware has recognized that those cases in which that type of evidence was introduced are very troubling and have to be looked at very carefully going forward. And so we're looking at some of those hair analysis cases where that type of evidence was misleadingly placed before the jury. Bite mark analysis, it used to be, does everybody know what that is? Like you would look at an injury and look at somebody's dental work and be like, oh, we can match the bite to the person's dental records. It's kind of strange. Handwriting analysis, same thing. Lead analysis, gunshot residue tests have been found to be very unreliable. Tool mark analysis, the ability to tell what bullet came from which gun based on the markings on the bullet. And fingerprints, arson investigation has really evolved, as has fiber comparison. So for example, with arson investigation, it used to be that they would say, oh, well, we could tell that an accelerant was used in this case by the manner in which the burning happened. And it was believed that certain types of accelerants created certain burn patterns or created certain types of, destruction of structures. And it's just been determined that that's not really accurate, that a lot of what we thought previously is not accurate. And yet people were convicted of using accelerants and convicted of arson and sometimes homicides, despite the fact that the science was unreliable. Next slide. What we find in wrongful conviction cases, as we're talking about these types of factors individually, but what we find is that when we have a wrongful conviction, it's a lot like a train wreck or a car crash. It's not just that somebody was texting or that the weather was bad and they went through the stoplight and, somebody else wasn't paying attention. So it's a cascade of errors. Oftentimes it means that the defense attorney wasn't really challenging the prosecution's evidence as well as it could have been. And maybe the prosecution wasn't turning over evidence that was helpful to the defense as they should have. And witnesses could be dishonest, but oftentimes it's not just one factor that leads to wrongful conviction. It's a combination of a lot of different factors that can lead to it. So the post-trial practice is very, very challenging, and it's particularly challenging in Delaware. So it's very difficult to raise a claim of actual innocence post-conviction. And you can go to the next one. So where is innocence mentioned in the Constitution? Trick question, nowhere. So there is not really an independent constitutional right to not be convicted if you are innocent. And motions for a new trial often have very high evidentiary standards that have to be met across jurisdictions. And so what you would have to show is that there's new evidence that probably would have resulted in a different outcome. And that's often very hard to meet that standard. In Delaware, we have it particularly hard, I will say. Convicted individuals have a right to counsel only in a first petition for post-conviction relief for certain levels of crime, but not for subsequent petitions. So somebody could find out, for example, in that hair analysis case that I was talking about, they could find that out years after the fact, and they will have done their first post-conviction motion, and then they wouldn't have a right to counsel for the next one. So we see a lot of people filing subsequent post-conviction motions without the help of attorneys. And it's very, very difficult for somebody to piece together a compelling motion. I mean, even practitioners have a difficult time piecing together a compelling post-conviction motion. So people who are left on their own have very little chance of being successful. Our post-conviction remedy in Delaware is Rule 61, and it creates a lot of barriers to successive petitions. So that means that once you file a post-conviction motion in Delaware, you are barred from filing another motion, even if new evidence is available, unless you can prove that the new evidence would show that you were innocent. So the way of getting around the defaults of our Rule 61 motion for post-conviction relief is to demonstrate that you were innocent. And it's a very high barrier. And the Delaware Supreme Court has only recognized one person as meeting that criteria, and that was Mark Purnell, we worked on that case at Innocence Project Delaware. But that was a relatively recent case. And since there's only been one. And part of the problem is that the presumption of innocence ends once somebody is convicted. And so there is a presumption that that conviction is valid. And it's very difficult to overcome that. So next. So I wanted to go through how race, because we started by talking about racial justice. I think the library is now officially closed. Okay, we'll just keep going and going. So I wanted to focus specifically at the end about how race impacts the problem of wrongful conviction. And what I said at the beginning is really true. At every stage of the criminal process, racial disparities make wrongful conviction more likely to impact people of color. So it comes down, I mean, Charlotte was talking about this a little bit with Michelle Alexander's book, The New Jim Crow. It comes down to at every stage of our criminal legal process, bias is present. And so how the police investigate, how they interrogate, bail proceedings, what pleas are offered, the right to counsel, jury selection, witness credibility, and sentencing and post-conviction, all of these aspects of our criminal legal system, race plays into, and we'll go through some of these. So next slide. So factors impacting investigation. So we know that police police differently in communities of color, that communities of color are traditionally over-policed, that stop and frisk policies are practiced in a way that have been demonstrated time and time again to have racially unfair impact. We see racial profiling where people are stopped just based if you're on the New Jersey Turnpike and you're a Black person driving in a beat up car, you're going to be stopped in a way that a white person is not going to be driving a nice car. It's just the fact. We see difficulties we talked about with cross-racial identification. Facial recognition technologies are also less reliable when it comes to people of color. They tend to overly target people of color, racial recognition. And this results in the overrepresentation of people of color in mugshots used for identification procedures, and that results in an increasing likelihood of misidentification. So bail determinations and guilty pleas. So economic disadvantages mean that people are less likely to make bail. And the longer people are forced to stay in jail pre-trial, the more likely they are to plead guilty, even if they're innocent. So one of the most frustrating things when you are a criminal defense attorney practicing in post-conviction phases is that oftentimes you'll be successful and you'll get a reversal of a conviction, and then a new trial will be ordered. And oftentimes your client will not make bail and they will remain in prison as you continue to fight the trial. And that happened in the Purnell case, where eventually Mark Purnell was exonerated. But what we find is that the longer people are forced to remain in prison pre-trial, oftentimes what happens is the prosecutor will say, okay, listen, your client can go home today, just has to plead guilty to time served. And so it's really, really frustrating. And it is that bail, the failure to make bail, and the pretrial detention, which impacts people of color to a much greater degree than people than white people, that exerts that pressure on people to plead guilty. So that's why we see these statistics. Nationally, 25% of exonerations involve guilty pleas. Okay, so that means only a small percentage of exonerations involved guilty pleas. Of that 25%, 75% were people of color. So that just shows you the disparities and how these factors come into play. Next. So we also see official misconduct more in cases involving people of color. So a 2021 study of cases involving official misconduct found that 79% of cases were impacted for Black exonerees from death row, and 69% of cases of Latinx exonerees on death row. And suggestive ID procedures are used twice as often in cases involving Black and Latinx suspects. So jury service is another area where we see racial disparities really impacting communities of color. So we know that there's racial discrimination in jury selection. Jury venires, which is the pool of jurors who are selected, are often drawn from driving records, voter registration records, and oftentimes people with any criminal convictions, felonies, are disqualified from those venires, from that group of people who's called and are eligible to serve on juries. And then assuming that you get, so it's not uncommon to go into a criminal court, and it's the same in every jurisdiction that I've been in. When you go into when you go in for jury selection, oftentimes the people who are called are disproportionately white. And that impacts the ability to get a good cross-section of the community serving on juries. And once the people are called and selected, prosecutors routinely challenge those with criminal contacts. And that has, again, a disparate impact on communities of color. Truly diverse juries are absolutely essential to the fair administration of justice. And that doesn't mean juries that are 11 white people and 1 person of color. It means truly diverse juries that represent the community. But we don't see that very often. We find that diverse juries deliberate longer and tend to assess evidence more carefully. Race impacts how witnesses are assessed, so people are more likely to credit those who look like people they know, love, and trust. And this was a really interesting study, a 2018 study by the National Bureau of Economics Research did a virtual reality trial. And the only factor that, so in other words, same witnesses, same evidence was put in, but the only difference was they had people watching the trial through virtual reality headsets. And so they could change the race of the defendant. And what they found was that when you changed the race of the defendant, there were higher levels of conviction for people of color. And when they were asked to give recommendations of sentences, people recommended higher sentences. So that study is just such a stark example because it's the exact same trial and we're just controlling for the race of the defendant. And so it's just really, really disheartening. Next. So also race impacts the amount of time that people serve in terms of once they are wrongfully convicted. So on average, Black exonerees serve 3 years longer until they're exonerated than white exonerees in murder cases. They serve 4 years longer in sexual assault cases. And the National Innocence Project reports that 66% of the people it has exonerated are people of color, and more than half of those listed on the National Registry of Exonerations are Black. And that lists all the exonerations since 1989. So that is all of I wanted to leave some time for questions about our project, about wrongful conviction, about anything.
Why? I mean, there's so much information up there in terms of a bad system.
Yeah.
Why?
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 Why? Is
Why
this
do we, why in this, and I love to say greatest, because on every aspect we're the greatest nation in the world. We've got this great constitution where everyone is equal. Why do we go through a process that does this? Because that has to be solved. You can solve some of those problems, but if there's something above it, like Michelle says, a permanent caste system, or this is just an updated version of Jim Crow, but it's a legal update of Jim Crow, because all of these are, legally covered.
Yeah.
I mean, you're working on changing some of these things, but
we're working on trying to make some of these things that we recognize. And I think it's important to use, data and science to try to counter this, to try to make laws that, for example, now in some jurisdictions at jury selection, the jurors are instructed about implicit bias, right? So at the beginning of the jury selection, of the jury service, there's a whole taped recorded message that tells people about implicit bias and about how racial disparities impact the justice, just to make people more aware. Some of these problems that we see about, misidentification, confessions, there are steps that can be taken to limit the problems that exist, with suggestive identification. There are things you can take, but the reality is that I do believe that the criminal legal system has traditionally been a way of controlling people. And, I brought a book back there, some books and some reading materials. We had Justin Brooks, who's the head of the California Innocence Project, come and speak to, or he's a former head. He came and spoke at our gala. And he has a whole chapter in his book about racial disparities in and how you're more likely to be convicted wrongfully if you're Black. Yeah, did you have a question? Okay, so I think that historically the system, there's debate. I mean, I think the system works the way it was intended, as a way of controlling people. And I think certain people have been very honest about that, like that it's been a strategy. We see the Willie Horton commercials. We see the differences in the criminalization of cocaine versus crack. There's just so many things that are built into the system that are designed to impact people unfairly. And so it's just raising awareness of that and naming it and working to make our system more fair. Go ahead.
Right. And so we'll go ahead and have the audience ask questions. but make sure that you pick your microphone up, very close to your mouth, please.
Yeah, thank you, Jack. A number of years ago, I had a discussion with a sitting representative in the Delaware House on that, and I had a question to him about mistakes that had to be made in convicting people, and we were specifically talking about the death penalty.
Mhm.
And I asked him what his acceptable error rate was for wrongful convictions on the death penalty. He was on my front porch, and he said to me, "We don't make errors like that. The Delaware has a perfect record on that." And going back, and he was a representative for a number of years here. And going back to our legislation, that's where the laws are made.
Right.
And the laws will have that bias built into them, and I suspect have for a long time. But it's folks like that just cannot see that there's a possibility that there could be an issue there, just saying, sorry, we don't make errors like that.
Right. Yeah, I think it's I mean, in the times where I've had cases where it's the prosecution has acknowledged that that the person was innocent, it's very difficult for prosecutors and legislators to do their job, right? And to prosecute people if they feel that the system is as flawed as it is. So there's a tendency to want to deny that the system is as fallible as it is, because it's a scary prospect. And so how can we be sure about anything? And I think that's part of it, that we don't make mistakes like that. We all want to go to sleep at night believing that we have the greatest system in the world, the most reliable system in the world, and that we don't make mistakes like that. But we cannot deny that we do make mistakes like that, and that we have to, and that when you're talking about the death penalty particularly, there is no acceptable error in that. There can't be.
I head up a national group against the death penalty. A couple of things that I want to mention. Number one, in case of death penalty cases, the primary reason you get the death penalty is the skin color and the sex of the victim
Right. So we see when there's,
and child.
yeah. So we see when it's a person of color and the victim is white.
And on the other side of the coin, problem with why do so many minorities get convicted is quite often bad representation.
Yes.
I was appalled one time. I was on a jury, but not a death penalty jury. And I ended up doing the public defender's job and talked the other juries out of a conviction.
Mhm.
That is a serious problem because quite often you have a really skilled prosecutor
Mm-hmm.
and you have a whole very hard working, overworked public defender in a death penalty case. And it's not fair. It is really not a fair situation. And that racial disparity is so prevalent
Mhm.
because a lot of it is economic, but a lot of it is skin color.
Mm-hmm.
And people need to understand that. And we have to work hard not to get the death penalty back here.
Definitely.
Because I had a letter from candidate Carney that said he wouldn't bring it back. And then we had the case of a lifer killing a guard.
Mm-hmm.
And he said, well, maybe we have to keep pushing him not to bring it back. There's a bill every year.
Do we have, before we go to questions from the online audience, we have more questions from people here in the room?
Yeah, I just recently moved here from DC. I have two nephews that are serving life sentences in federal prison. And one of them, and just to talk about the Innocence Project, one of them had met the criteria to be accepted by the Innocence Project. But that was just the beginning, even though the other one didn't. And the one that he's still working with the Georgetown Innocence Project group, and they're doing great work.
Mhm.
But I mean, just getting that past that original hurdle that says you meet the criteria, that's just the beginning. And
Right.
so
I
he's
mean-
been working with the group since it's been a couple of years now,
Yeah.
and he's still working with it.
Well, the average amount of time for people and from the time they're convicted till exonerated for DNA cases is 14 years. So people don't realize how long The average, yeah, is 14 years. I mean, you look on I would encourage you to go to the National Exoneration Registry and just look at some of those cases. I mean, there are people who have served for 40 years and are then exonerated. So it is a very arduous process to exonerate somebody.
And
But
let's,
I'm sorry to hear about your relatives, and I wish them luck.
can we go ahead and pull up the Q&A, please, for online? So we have a couple of online questions, and one of the questions deals with, what can we do in our everyday lives to help? Obviously, we can donate money, but what else can we do in our own everyday lives for awareness and bring about change?
Yeah, I think there's a few things you can do. I think, first of all, it's really good to support organizations that are doing work to help our criminal legal system become fairer. It's important to be informed about the legislation that's before your individual representatives, elected representatives. It's important that you give your support and work for people who are on the right side of these issues and actively get involved. It's important that you serve on juries and that you educate yourselves about the problems with the criminal legal system. So when you're called to serve on a jury, I'm always eager to serve. Nobody's ever eager to have me, but I am always eager to serve. And right, I know. The defense is eager to have me, but the prosecution, not so much. So I think it's really important that you educate yourselves, that you're good citizens, that you're invested citizens. And it's really easy. People always say to me, well, how do you not get beaten down by this work? And it's really important that we don't lose energy and that we don't become defeated, because we really if we want to have a just society, we really all have to be in this fight. And so it means that figuring out how you can contribute, whatever way that is, maybe it's talking to somebody, reading a book and engaging people on these issues. Maybe it's, going to fundraisers for people who are on the right side of these issues and actively supporting them. So there's many different ways of getting involved and improving the situation. And it's just a question of where you feel you can contribute.
And there's a follow-up. Are there ways that we can work with our legislators? Can we call them? Is there any legislation that's pending coming up for this coming session?
Well, we've been working on the exonerate compensation bill so that people who have been wrongfully convicted in Delaware, there's not that many of them. We've been working on that bill to make sure that they have adequate support and resources when they get out. So that's one of the bills that we're currently working on. But whenever we hear about if the death penalty bill is reintroduced, we'll be fighting against that. So it's important that you keep educated about what's pending and figure out where to intervene.
Session are going to be criminal justice bills. So if you go on the website of the state legislature, you can pick up all the bills that are about to come out in January. Some have to do with bail reform.
Mm-hmm.
Some have to do with sentencing. Some have to do with solitary. Though we've
Law
been around the
Enforcement Bill of Rights.
Law Enforcement Bill of Rights. There's so many of them, and they're all part of the process.
I know she.
Thank you for your presentation. It's been very informative. You talked about how there's just barriers, with Delawareans who are incarcerated and the legislation is not in their favor. Is there anything that can be changed about our prison or carceral system here to help give more access to individuals who are wrongly convicted to get to their attorneys, to write letters, to reach the people like you that they would need? Or, do you know of any barriers?
Well, I think one thing that would have to change long term is the statute that governs post-conviction relief. It's been made, it was changed and modified in around 2014 to make it more restrictive. I think it would have to be changed to make it more, not liberal, but just more easier, a little more easy for people to get back into court. I think there's always in every system, there's a fear of opening up floodgates or, not having finality of convictions. But there has to be a better balance in that statute. And so that's something that I would want to see changed going forward. And also, I think it's important that people know that we're here, right? And so Charlotte today just told me about a case of somebody. So if anybody hears of somebody who they think is wrongfully convicted, you have our information, you can give them to. I mean, we are a very small project, but we review every application very carefully and look very carefully into all of these claims. So I hope that answers your question.
Yeah, thank you for coming. I really appreciate this. It's really informative. How do we compare to other states? Are there certain states that are doing well with regard to exonerations and some that are absolutely horrific, and where do we fall?
Well, I think that Delaware has not. If we look at Delaware in terms of the strength of the wrongful conviction community here. So, for example, I'm from New York. In New York, every public defender office has its own wrongful conviction project within its post-conviction office. There are also freestanding exoneration initiatives in New York, in the city, and where we see a really robust bar presence of people doing wrongful conviction work, we see a lot higher level of exonerations. In Delaware, we haven't had that traditionally. And so, as I said, we were only started taking cases since 2020. A lot of these projects date back to 1992. So I think Delaware is behind in terms of wrongful conviction work. And I think there's a feeling in Delaware, which is common in most jurisdictions, that, we don't have those problems here. Like what you were saying is like, oh, we never made those mistakes with the death penalty. I also think that the existence of the death penalty in Delaware for so long had a disruptive effect on the criminal legal system, because oftentimes when we speak to people who were trying cases under the capital system, first of all, they were completely overburdened in terms of the number of capital cases that they were handling. And so what did we see as a result of that? People were focusing just on saving the lives of their clients, not necessarily on the facts of the case or guilt or innocence, but mitigation to try to prevent people from being killed. And you understand that if you are representing 5-6 people in capital cases, there's no way that you can do an adequate job on that. And so it has nothing to do with the talent of the bar, but it's just the demands being placed on the bar were just too much. We were too great without an understanding of the impact of that on the outcomes.
Thank you. And before we close down for the day, before I hand the microphone back to Charlotte to end, just want to say, please go to the Innocence Project website. There's a button there to donate. There's also on our website, the Southern Delaware Alliance for Racial Justice. We also have a donate button, so please go there as well. And also, Miss Claudia Trupp has a book that she's written, so look for her name online.
And also I brought some t-shirts, and I also have copies of Justin Brick's book if anybody wants to get those.
I'm going to pass the microphone off to Charlotte King, our founder.
If you don't mind, I'll sit. I thank all of you for coming. Claudia, I have to thank you. I think it was a wonderful presentation. And the fact that you can give us that much information without ever looking at a note, I think is just awesome. But thank you. But I owe you an apology. I gave Claudia a application tonight from 4 women who live here in Sussex County who have been trying to get someone out of a conviction who's right now in Vaughan. And they want desperately, they believe this man is innocent. But you have an application process, and I just gave you a case and said, so I will tell them they have to apply. Thank you. I also want to apologize because the Alliance started really passionately about criminal justice reform. And for those of you who have been with us for years, you'll remember we had Justice Leo Strine, we had the Office of Defense Services, we had the prosecutor, we had everyone we put on the spot. We had men and women who had been released from prison. That was our major focus, and we dropped it. And I think of Michelle Alexander, who said, That's the problem with many failures, that you don't stay focused. I'd like to see us return. I'd like to see what ways we can work with you in terms of keeping up at least the note to the community or the people that there are reasons for this, and it's part of a bigger system, a very insidious system. So I welcome all of you to join us as we continue these conversations and find ways of informing, because that's our mission, to inform and to educate about injustice, whether it's in the criminal justice system, whether it's in the education system, which is a second priority. And then there are some others. But I think we're going to go back to it, and I hope that we can collaborate with you on issues. But thank you very much, all of you, for coming.
Yeah, we actually ran a prison reform ministry in DC, Maryland, Virginia for about 30 years. And I've been in discussion with Susan, and we've been talking to the various groups that are involved in some aspect of prison outreach. And we're looking to bring together all the folks within Delaware, do a gap analysis and see, what's being done, connect the dots, and see if we can fill some of those holes. So we're just in the process of coming up with a strategic plan to bring those groups together. We've talked to several groups, and I think Susan will probably be within the next month, right? We should be bringing a group together. So if you want to volunteer for this committee, contact Susan. But it's about 4 or 5 groups we've met with so far that are doing work in this space, but they're not working collaboratively. And that's what we want to try to get a handle on.
That's that Joe Lawson, who is another one of our board members, who is connected to a group called DETER, which has 200 volunteers and alliances, can suggest that's one of the actions they can take that is useful and constructive, is to meet with this young man and Susan and join them in the work to do criminal justice reform.
And Melvin is a recent DETER graduate, and he'll be part of the alumni group.
All right, thank you all very much. Have a grand evening. Thank you all for coming. Thank you all. Good night.